Welcome once again to Lehto's Law. Here's Steve Lehto.
I had a whole bunch of people send me a story from Reason.com, and this is one of those stories that when you read it, you go, this couldn't and shouldn't be possible. This shouldn't be possible. But here we are. Georgia man has been jailed for 10 years without a trial. 10 years in jail waiting for his trial. And you might recall that the Sixth Amendment to the U.S. Constitution guarantees you the right to a speedy and public trial. A speedy trial. The right to a speedy trial. 10 years ain't speedy. So in 2013, the man was charged with murder. 10 years later, he's still languishing in a county jail awaiting trial. Emma Camp wrote this story and says that 10 years later, after the man was charged with a crime, he still has not yet received his trial. His two co-defendants were both acquitted in 2017. So there were 3 people charged in this crime. 2 of them were acquitted in 2017, 4 years after the charges. And yet this guy, who did plead not guilty, is still sitting in a county jail in Georgia with little hope of a trial anytime soon. In other words, he's been in jail 10 years. Does he get a trial now? No. Soon? Not really. He hasn't had a lawyer since last summer. According to the local district attorney, several factors have led to his absurdly long wait time for trial. The district attorney told Atlanta News First that the COVID-19 pandemic and a 2021 courthouse flood and the decision by the previous judge to try each of these defendants separately all caused different kinds of delays, which added together make a really long delay. Making matters worse, he says the county's been unable to find a public defender for him, which has lengthened his time behind bars because he's asked for a public defender and he's entitled to one. So this case, it's a rare situation, says the district attorney. We want to get to trial eventually. Now, while these recent issues have considerably slowed down the path to trial, it's not clear why he wasn't tried before 2020, because remember, his co-defendants were tried in 2017. So he's been left without an attorney for the past 8 months due to a particularly Kafkaesque string of bureaucratic errors. According to the news, his old attorney filed requests in July and August of last year to be released from the case, citing that he would need to travel frequently, which he could not do because his infant daughter needed medical care. So it's not like the guy bailed saying, I don't want to represent this guy. He's saying circumstances of mine make it to where I can't represent him. The local county clerk's office misplaced a judicial order formally releasing the attorney from his position. When the defendant sent a request for a new attorney in September of 2022, it went unnoticed. His request went unnoticed, according to a judicial assistant, because court employees lost the attorney's request to be released from the case. He was technically listed as the attorney until April 12th of this year, seemingly only after journalists started asking questions. The defendant never received actual legal help from the attorney during that entire time, and the Georgia Public Defender Counsel insists that the defendant has had access to legal counsel during the past 8 months despite that error. A court error, if one took place, does not obviate the attorney's responsibilities for representation, says the Public Defender Counsel's communication director. In law and in fact, he was the defendant's attorney until April 12th. Assertions to the contrary are deliberately misleading. It's unclear why the Public Defender's Counsel is so keen to say that, but the news notes that Georgia's public defender system is plagued with issues, primarily understaffing and difficulty retaining attorneys. One judge insists that we have too few public defenders for the work to be done, adding that the lack of public defenders slows down the judicial process. However, the director of the Georgia Public Defenders Council disputes this, saying we have more employees than we've ever had in the history of the agency. We have more funding than we've ever had in the history of the agency, and that's the last 2 years. Well, if that's true, why don't you step up and take care of this guy who's been rotting in jail for 10 years? Don't defend yourself, defend him. Regardless of where these issues come from, it's clear that something is very wrong When sloppy bureaucracy goes unchecked, defendants like this one cannot afford their own lawyers, must rely on public defenders, are in danger of being effectively denied their Sixth Amendment right to a speedy trial. To claim that the defendant was represented under these circumstances makes a mockery of the right to counsel, says an attorney for the Southern Center for Human Rights. That is certainly not the type of representation anyone of means would pay for. And so I would argue right now that they need to get this man an attorney ASAP, who needs to immediately file a motion for dismissal on the grounds that he's not been granted a right to a speedy trial. And the speedy trial, as noted, is guaranteed in the Sixth Amendment. And so you might say, but Steve, the Sixth Amendment is speedy. Does it actually give a time frame? Does it? Does it give a time? No, it does not. And I think they did that purposely, because everyone knows that if you give a time frame with a drop dead date, there always could be some reasonable explanation why it might go one day over or something. But it would also seem to be that certain kinds of crimes might take a little longer to bring to trial than others, okay? So as you can imagine, there's some very, very complex trials out there and also some very important trials out there. And so if you were accused of jaywalking, it's hard to argue and say, well, gee, I need a year to prepare my defense for the jaywalking trial. And the people aren't going to say, oh, we need a year to prepare for the prosecution of this jaywalking trial. No, that's not going to happen. On the other hand, might it take 6 months or a year to prepare a good defense on a murder trial? It might, if there's all kinds of like DNA evidence and you have to bring in experts and there's only like 3 experts in the country who handle a particular kind of testimony and evidence. It might be that you need 6 months or a year to get that ready. 10 years? No, not 10 years. And the one thing I'd like to point out to you, it says here the man's been charged with murder. And I'm not exactly sure exactly what the charges are. And the reason I'm saying that is I've heard of people who've been charged with various forms of associated crimes where someone is accused of killing someone else, such as manslaughter or second-degree murder, things of that nature, who have spent less time in jail after being found guilty than this man has spent in jail waiting for trial. Now, obviously, if the man is found guilty, they'll give him credit for time served, and he'll already be 10 years ahead of that. But if he's found not guilty, the guy just spent 10 years in jail for nothing. And that is the crying shame of it. So, this is something that is so absurd that I almost thought it was like an Onion story. But it's from Reason.com. Emma Camp wrote it. Thanks, everyone, for sending it to me. And maybe if enough publicity and enough light is shined on this man's situation, maybe they'll do something. And the first thing they do is appoint him an attorney. And then his attorney should look at this and go, oh, you spent 10 years in here and no trial? Gee, let's bring a motion under the Sixth Amendment. And I suspect that Georgia's Constitution might contain similar language as well. So there you go. But this Georgia man has been jailed for 10 years awaiting trial. And don't forget that his co-defendants had trials within 4 years and were both acquitted. So you've got acquittal, and then we'll wait 10 years to try the third guy, which seems crazy. And there you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The first step is you have to say that you can.